Probate practice. Probate is the authority that validates the powers and functions of an executor, although the authority of an executor to act derives firstly from a will. An administrator derives his power to act first from the grant of the letters of administration. To this effect, while the probate confirms the representation of an executor, a letter of administration confers the representation of an administrator. Distinction between probate and letters of administration. Probate operates where the deceased dies, leaving a will. In this kind of situation, the deceased is said to have died testate. Letters of administration, on the other hand, applies where the deceased died without leaving a will. Here is said to have died intestate. In granting probate, it may be contentious or non-contentious. It is non-contentious where there is an existing dispute over the will. Factors that makes a probate to be contentious: 1. Where the will was not validly made. 2. Where people who applied for the probate are not the appropriate persons to apply for and obtain such grant. 3. Where there is a caveat at the registry. Procedure to obtain probate and letters of administration in non-contentious cases: 1. Discovery of the will. 2. Where the will is discovered, the solicitor or the executor will need to intimate the probate registry of the discovery of the will. The testator might have already deposited the will at the probate registry. The solicitor writes to the probate registrar intimating him of the following things: A. The death of the testator accompanied with the certificate of death. B. The place of death and the date of death. C. The fact that the testator lived within the jurisdiction of the court. D. The fact that the testator made and deposited a will at the registry. E. A list of the names of persons interested or likely to be interested in the estate of the testator. F. A date is subsequently fixed for the reading of the will. On the date fixed, the registrar of probate brings out the will, breaks the sealed wax on it, and reads the will in the presence of persons present, and makes a record of the proceedings of the day. Ajibaya and Ajibaye, 2007, 18 LRLR, Volume 8, 911. G. An application for the grant of the probate will be made by the executors. This is done by filling and completing the relevant forms as well as submitting the accompanying documents. H. Assessment of the estate is conducted by the registrar and the executors are made to pay the prescribed and assessed fees. I. If the probate registrar is satisfied on the compliance with the requirements, he grants probate to the applicant with a copy of the will attached to the probate, or he grants the letters of administration. Checklist of necessary documents required for the grant of probate and letters of administration are: 1. Application for probate or letters of administration. 2. Death certificate of the deceased stating where and when he died, his last place of residence, sex, and age. Very important, the most authoritative death certificate is Form D2 issued by the National Population Commission. Yes, boss. 3. A declaration on oath by the executors stating the following: A. That the deceased is dead. B. The date of his death. C. The executors believe in the validity of the will. And D. That they will faithfully administer the estate of the deceased and render accounts to the term of the will. 4. Oath justification by sureties on behalf of the applicant in a specific penal sum to guarantee his administration of the estate. 5. A duly completed bond by the applicants to pay the debts and liabilities of the deceased estate, to distribute the estate, and also to make inventory. 6. An authorization by way of a bank certificate issued by the probate registrar to personal representative or applicant to inquire into the details of the bank account of the deceased. 7. A duly completed inventory specifically listing the properties of a deceased person which the administrator wishes to administer. 8. Where it is an application for probate, a sworn affidavit of attesting witnesses to the will stating that they are witnesses to the executed will. 9. In the case of letters of administration, an evidence of publication in a newspaper. 10. Passport photographs of the applicant and witnesses to the will. 11. A declaration of the next of kin. Very important, in the case of probate, a copy of the will shall be attached to the application. Procedure to obtain probate and letters of administration in contentious cases. 1. An application is made by the applicant accompanied by the documents listed in the application for non-contentious grants. 2. A caveat is entered. A caveat is the act of entering objection by a caveator to the sealing of the grant and making the grant of probate contentious. It is also called notice to prohibit. Where the probate registrar is aware of an effective caveat, he shall not allow a grant to be sealed. A caveator is one who files a caveat. In Lagos, caveat is entered by completing Form 3 or Form 4 is completed and signed by a legal practitioner. Once entered, the caveat lasts for 3 months in Lagos and 6 months in Abuja. Generally, the procedure for the grant of contentious probate has been decided and laid out in the case of Danjumbo and Danjumbo. 3. Warnings and citations. This is a notice given to the caveator to appear either before the probate registrar or the court within 8 days from the date of the service of the warning on him, and give reasons why probate should not be granted, or to state his interest in the estate. Order 55 Rule 7 of the High Court Civil Procedure Rules of Lagos State. If no contrary interest is disclosed or no summons is served by the caveator within 8 days of the warning, the court may proceed to issue a grant of probate in the estate notwithstanding the caveat. 4. Appearance. Where the caveator wishes to respond to the warning, he is required to file an appearance to the warning. In the appearance, he should disclose the nature of his interest in the estate and why the applicant should not be granted probate. 5. Probate action. Where the caveator enters appearance, probate will not be granted, but the matter will be heard in court for the grant of the probate in solemn form. The action can be commenced by way of writ of summons, especially where there are substantial allegations of fact. An issue arose as to the proper mode of commencement of probate action in the case of Igumbo and Afolabi, 2001, Federation Weekly Law Report, part 59, at page 284. The question was whether it was correct for the appellant to have applied to be joined as a co-administrator of the estate by way of motion or notice or a writ of summons. The court, relying on Coker and Coker, held that there is no reason why such an application cannot be brought by motion. However, it is safer to commence such an action by way of writ of summons, considering the fact that the matter is a contentious one. Hearing is done in open court with evidence taken on both sides. The court will not sit on the fence. The court at the end of the day must agree with the evidence adduced by one of the sides. Where the court at the end of the case pronounces in favor of the will, probate will then be granted in favor of the will. Where the court does not pronounce in favor of the will, no such probate will be granted. The only option the parties would have is the option of appeal. When can double probate be granted? A double probate is said to exist where a probate had earlier been granted and another application is made for probate on the same estate. While the first is the original grant, the second application or grant is the second or double grant. In an application for double grant, in addition to the documents that ordinarily accompany an application for a grant, the particulars and copy of the original grant should also accompany the application. Double grant arises in a number of situations, viz. 1. Where one of the executors was a child at the period the original grant was made to others, he can apply for a double grant upon reaching the age of maturity, and this is on the condition that there is still vacancy. There won't be vacancy if the executors of the estate were already 4 in number. 2. Where one of the executors is not available as at the grant of the earlier probate and did not renounce his appointment and was neither removed, he may apply for a double grant subsequently. 3. Where the earlier grant was made to the maximum number of executors, but there is still 1 or 2 persons out. Where there is vacancy either by death or resignation of any of the executors, the outstanding person can apply for a double grant. Letter of administration. A letter of administration could be made 1. Where there is no will, the testator died intestate. 2. Where there is partial intestacy, which could be as a result of the absence of a residuary clause. 3. Where the will was made but has been rejected by the court. The effect of this is that the testator's will not be followed. Order of obtaining letters of administration. Section 49, sub 1 of the Administration of Estates Law of Lagos State. 1. Surviving spouse. 2. Children of the deceased and issues of such children. 3. Parents of the deceased. 4. Brothers and sisters of the same blood with the deceased. 5. Brothers and sisters of half blood with the deceased. 6. Grandparents of the deceased. 7. Uncles and aunts of the deceased. Very important. Ordinarily, the court has to follow the order, but the court is allowed to use its discretion in administering letters of administration. The administrator of the estate will take over and declare the property von ficando. The major practice that distinguishes the process of obtaining probate from letter of administration is publication of application for the grant of administration in an official gazette or in a newspaper circulating within the jurisdiction. The purpose for this is to give members of the public the opportunity to make objections to the application for the grant. Concept of resealing. Ordinarily, probate or letters of administration are granted in respect of properties within a state's jurisdiction. However, the testator might have had properties outside the jurisdiction which issued the probate or the letters of administration. The executors are not obliged to apply for probate in each of the jurisdictions where testator's properties are located. Once probate is granted, what the executor needs to do is to reseal the grant in those other jurisdictions. Section 2 of the Probate Resealing Act. Conditions for resealing. 1. The probate duty must have been paid in respect of the value. Such estate is liable to probate duty in that state. 2. In case of letter of administration, security must have been given in a sum sufficient in amount to cover the property in that state to which the letters of administration relates. The court may require such evidence, if any, as it thinks fit to the domicile of the deceased person. Refusal of grant of probate. The court will usually refuse the probate on the following grounds. 1. Where the applicant is not in the category of persons mentioned earlier, e.g. children, parents, blood relations, etc. 2. Where there is no sufficient proof of the death of the testator. 3. Where the applicant is not such a person with the best interest of the deceased at heart and will likely mismanage the estate. 4. Where the applicant is an infant except he is jointly applying with his parent or a guardian. 5. Where the court, having regard to all other circumstances of the case, feel that it is not just to grant a probate or letter of administration to the applicant. Revocation of grant. A grant may be set aside in the following ways. 1. Where it is obtained by fraud. 2. If there is a subsequent wrong act by the administrator of the estate. 3. Where a subsequent will or codicil is discovered which supersedes the will upon which the first grant was made. 4. Where the deceased is discovered not to be dead. 5. Where it is later discovered that the will has been revoked by the deceased in his lifetime. 6. Where the executors consent that the grant is revoked. 7. Where the grant was made to a person whom it ought not to have been made. Otun and Otun, 2004, 14 Nigerian Weekly Law Report, Part 893. General grant is given on the whole estate of the deceased without limitation as to the time and the extent of the estate to be managed. Limited grant, on the other hand, is granted upon the happening of an event, i.e., time is given and the extent of the grant is specified. Ethical issues. 1. A lawyer should not circumvent the provisions of the law. He should ensure that he submits documents to the probate registry, Rule 1 of the Rules of Professional Conduct. 2. A lawyer should not alter any testamentary document in his favor, Rule 15 of the Rules of Professional Conduct. Very important, in Abuja, probate cannot be granted within 7 days of the death of the testator, and letters of administration can also not be granted within 14 days. In Lagos, the court cannot grant probate within 14 days of the testator's death, and letters of administration within 21 days. Quick glance note is powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 091569137 and send your emails to rollumsandluxury@gmail.com, Instagram rollumsandluxury, Facebook rollumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.